And registrar is, can you unmute me, please? Good morning, registrar is, are all the breakout rooms now closed?
Yes, everybody is in the main room now.
Terrific, thank you.
You're welcome.
Good morning, Commissioner. My name is Rob Senta, and I'm lead commission counsel on the Red Hill Valley Parkway inquiry, which was called by the City of Hamilton. I'd like to open our public hearing today by acknowledging the City of Hamilton that called this inquiry is situated upon the traditional territories of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. This land is covered by the Dish with One Spoon Wampum Belt Covenant, which was an agreement between the Haudenosaunee and the Anishinaabe to share and care for the resources and the Great Lakes. We further acknowledge that the land on which Hamilton sits is covered by the Between the Lakes Purchase 1792 between the Crown and the Mississaugas of the Credit First Nation. Many of the council appearing at this hearing today are located in Toronto, which is on the traditional land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and I'm grateful to have the opportunity to work on this land. First, today, I would like to introduce the members of the Commission Council team that will be presenting the evidence and working on this hearing. With me today and off camera are Andrew Lewis, Emily Lawrence, Haley Bruckner, Shauna LeClaire, Chloe Henry, Lauren Rainsford, and Jacqueline Cummins, our law clerk. I'd also like to welcome counsel for the participants in the inquiry, and will ask a representative of each participant to introduce the members of their team that are present today. First, for the City of Hamilton, I see Eli Letterman present.
Good morning, Mr. Commissioner. I'm getting some feedback here. I don't know if you can, is my audio okay?
You're okay.
Okay, thank you. So I'm assisted here today by a number of colleagues who are with me. Delna Contractor, Jonathan Chen, Janine Roberts, Vivian Hua, Laura McIntyre, and Christina Shields Singh.
Thank you, Mr. Letterman.
Thank you.
Another participant at the hearing is the province of Ontario, who is represented by, among others, Ms. Heather McIver, and I invite Ms. McIver to introduce the members of her team.
Thank you. Good morning, Commissioner. I'm here today to represent the province and the Ministry of Transportation, and along with me is Colin Burrier, as well as Michael Said. Thank you.
The third participant represented today is Golder and Associates, represented by Jennifer Roberts, and I think there are some other colleagues of Ms. Roberts present today.
Good morning, Commissioner. Good morning, Council. Yes, I'm here today representing Golder, and I am assisted by two colleagues, Nivi Ramaswamy and Fabiola Besson. Thank you.
And finally, Dufferin Construction, and I see Ms. Lorian, oh, and there's Ms. McAleer representing Dufferin. So invite Ms. McAleer to introduce her colleagues.
Good morning, Mr. Commissioner. Good morning, Council. Jennifer McAleer on behalf of Dufferin, and I'm with Rachel Lorian as well.
Because of the ongoing COVID-19 pandemic, we will be conducting the public hearings via Zoom. The technological backbone for today's hearing is being provided by Arbitration Place. Wish to assure members of the public that all of the council for participants can see and hear the commissioner and all other council, all of whom are appearing remotely from each other. We've asked that after we get through the introductions, the council that are not speaking to turn off their cameras to reduce the visual distraction on the screen. So people who are watching via the live stream may not be able to see all of the council who are present at any one time. I expect that the Zoom process will go smoothly, but if any council has any problems or wishes to speak at a particular time, just turn on your camera. And we've also provided you with contact information for our friends at Arbitration Place who will assist us if something goes wrong. Each day of the public hearings will be streamed on YouTube. Members of the public are invited to visit the inquiry website at www.rhvpi.ca, where you will find a link to the live stream and archived versions of the live stream of the public hearings. In addition, written transcripts of the evidence of the hearing will be posted to the website within a few days after the day in question. And for members of the public who may be watching this, I suspect that all council will have a setup similar to mine, which is having multiple screens arrayed around you to try and keep track of all of the documents. That will cause all of council's eyes to dart around the screens. And we will not always be looking directly at the camera or at the witness, but that is a feature of this method of presentation, unfortunately. I want to start by going over some of the background to these public hearings. In May of 2019, the Honorable Mr. Justice Herman J. Wilton Siegel was appointed to preside over the Red Hill Valley Parkway inquiry. In early 2019, the City Council of the City of Hamilton received information regarding a 2013 friction report related to the Red Hill Valley Parkway. And on April 24th, 2019, City Council passed a resolution pursuant to Section 274 of the Municipal Act 2001, requesting the Chief Justice of Ontario to appoint a Superior Court judge to investigate matters related to the disclosure of the friction report. That resolution of City Council contained the terms of reference that will guide the inquiry's work. The terms of reference require the inquiry to determine facts relating to 24 questions posed by City Council, which fall into 5 general categories. First, issues around the friction testing conducted in late 2013 on the Red Hill Valley Parkway and the Lincoln Alexander Parkway, and the subsequent report based on it, including who was involved in or received the report, why it was not provided to City Council or the public, the circumstances surrounding it coming to light in 2018, the steps taken at that time, and the ramifications, if any, from the report not having been disclosed. Second, issues around the Ministry of Transportation of Ontario friction testing on the Red Hill Valley Parkway that was conducted in 2007, including whether the testing supported or rebutted the 2013 friction test results, who received those results, why the results were not provided to City Council or made available to the public, and the ramifications, if any. Third, whether the city or the Ministry of Transportation conducted any other friction tests, asphalt assessments, or general road safety reviews or assessments of the Red Hill Valley Parkway, and whether those test results supported or rebutted the previous friction test results. Fourth, what are the standards in Ontario, if any, respecting acceptable friction levels, and how do the test results on the Red Hill Valley Parkway compare with those standards? Fifth, to what extent do factors other than friction, including driver behavior, lighting, and weather conditions, contribute to motor vehicle accidents on the Red Hill Valley Parkway as compared to the impact of friction levels? The second part of the inquiry's mandate is to make recommendations regarding the matters I just mentioned that appear to be in the public interest, the interests of good government of the City of Hamilton, and the road safety on the Red Hill Valley Parkway. I'd now like to quickly review the principal activities of the inquiry since it was established and how that work will support these public hearings. On October 30th, 2019, the inquiry invited applications to participate and seek funding at the inquiry and published rules regarding such applications. We received 9 applications to participate. On February 12th, 2020, the commissioner released his decision and reasons concerning participation and funding at the inquiry. And he granted 4 entities the right to participate in the inquiry, those participants that I introduced previously: the City of Hamilton, Her Majesty the Queen and Right of Ontario, Dufferin Construction Company, a division of CRH Canada Construction Group, Inc., and Golder Associates Limited. On June 25th, the inquiry published rules of procedure, which are available on the website of the inquiry at www.rhvpi.ca. And these rules cover topics including the investigation phase of the inquiry, participants' obligations to preserve and produce documents to the inquiry, procedures for determining claims of legal privilege, the creation of an inquiry document database, the creation by Commission Counsel of documents that identify the core or background facts for use at the hearing, the process for interviewing persons that may have information that's relevant to the inquiry's work, the disclosure of proposed evidence prior to the public hearings, and rules for the conduct of these public hearings. In the Commissioner's decision on standing and funding, the Commissioner outlined several ways that other persons who did not have participation status could nevertheless provide information to the inquiry. These methods included contacting Commission Counsel with information and providing written submissions at the conclusion of the public hearings. In addition, the Commissioner set out that he intended to provide a forum in which individuals who had been personally affected by particular accidents on the Parkway could be consulted as part of the inquiry, even if reconstruction of any particular accident is unlikely to fall within the terms of reference. This forum was intended to provide any person who was directly or indirectly affected by accidents on the Parkway with the opportunity to provide documents and to schedule individual and private discussions with the inquiry's team to provide us with a fuller appreciation of the impact of particular accidents on the residents of Hamilton. The inquiry invited interested persons to advise us of their interest in contributing to the work of the inquiry through this forum, and 1 member of the public accepted our invitation. We had a very useful series of meetings with Belinda Marizzato, and we thank her for her participation and invaluable contribution. If anyone else still wishes to participate in similar discussions, they should contact me through the contact information available on the inquiry website. I want to speak briefly about the document collection process, because that took up a significant amount of the time and energy of Commission Counsel and has led to some of the work that I'm going to describe subsequently. Paragraph 2 of the resolution of Hamilton City Council directed the Commissioner to, quote, obtain, bearing in mind cost and the principles of proportionality, all documents necessary to answer the 24 questions posed in the terms of reference. Since the inquiry was called, Commission Counsel have been working with the participants to identify and collect relevant documents. We've also been working with entities that, while not participants, are anticipated to have relevant documents for our work. The inquiry issued summonses requiring the recipients to deliver up to the inquiry all documents covered by the summons. This process has been time-consuming for, among other reasons, the COVID-19 pandemic, and because of the number of years covered by the terms of reference. To date, Commission Counsel have collected over 135,000 documents. These documents have been loaded into a database to permit us to share the productions with the participants. We've reviewed all the documents that we've received and have communicated with the participants and others where we've identified gaps and omissions to see if additional documents can be located. There are still a number of documents that we believe are critical to the work of the inquiry, but over which the City of Hamilton has asserted a legal privilege. Later this morning, the City will be bringing a motion for directions to assist with the determination of whether or not the City is required to release those documents for use at the inquiry. We'll return to that motion for directions later. Now I'd like to discuss the overview documents, which will be the first exhibits that I'll be asking you, Commissioner, to enter as exhibits at the hearing. As I mentioned earlier, the Commissioner published rules of procedure for the RHVPI's investigation in public hearings. Rule 10 stated that the goal of the inquiry's investigation in part was to identify the core or background facts that would form the basis of overview documents. Commission Counsel drafted 10 overview documents, which in total number 1,500 pages of evidence and that summarize approximately 4,500 documents. The overview documents are organized primarily in chronological order. Between February 2021 and January 2022, Commission Counsel provided drafts of these overview documents to Council for the participants and invited them to review and offer comments and to suggest revisions to the overview documents. Commission Counsel received and considered and revised the overview documents where appropriate and circulated further drafts to the participants. I want to emphasize that the facts contained in the overview documents have not yet been tested for their truth. Commission Counsel and the participants may call evidence from witnesses at the inquiry that casts doubt on the truthfulness or accuracy of the content of the documents underlying the overview documents themselves. The participants will also be free to make submissions regarding what, if any, weight should be given to any one of these documents. The Commissioner will make the findings of fact in his final report after he has heard all of the evidence and received all of the submissions. And in doing so, the Commissioner is entitled to accept or reject some or all of the documentary and oral evidence at the inquiry. I would now like to introduce the overview documents into evidence and have them marked as the first exhibits. And I understand that this is on with the consent of the participants. Registrar, if I could ask you to please call up overview document number 1. Overview document number 1 is titled Introduction, and I ask that that be marked as the first exhibit. Registrar, could you please call up overview document number 2? Overview document number 2, City of Hamilton, Governance and Structure, and I ask that that be marked as the next exhibit. Registrar, could you please call up overview document number 3? Overview document number 3, construction of the RHVP. If I could ask that this be marked as exhibit 3. Registrar, could you please call up overview document number 3.1? Overview document number 3.1, RHVP design and geometry. And I ask that we mark this as OD or exhibit, 3.1, largely so we don't mess up the otherwise beautiful correlation between overview document number and exhibit number so early in the proceeding. Registrar, could you please call up overview document number 4? Overview document number 4, the Ministry of Transportation of Ontario and friction testing. If I could ask that that be marked as exhibit number 4. Registrar, please call up overview document number 5. Overview document number 5, the RHVP 2008 to 2012 and City Road Safety Initiatives 2008 to 2018. And if I could ask that that be marked as exhibit 5. Registrar, please call up overview document number 6. Overview document number 6, the 2013 SEMA report and the 2013 Golder and Tradewind reports. And if I could ask that that be marked as exhibit 6. Registrar, please call up overview document number 7. Overview document number 7, the 2015 SEMA report. If I could ask that that be marked as Exhibit 7. Registrar, please call up overview document number 8. Overview document number 8, 2017 pavement evaluation and RHVP related safety initiatives, November 2017 to April 2018. If I could have that marked as Exhibit number 8, please. Registrar, please call up overview document number 9. Overview document number 9, events leading to the discovery and disclosure of the Tradewind report. If I could please have that marked as Exhibit 9. And finally, OD or overview document number 10. Registrar, if you could please call that up for me. Thank you. Overview document number 10, disclosure of Tradewind report to council and public. And if I could ask that that be marked as Exhibit 10. The overview documents and the documents referred to in the overview documents will now be made available on the RHVPI website. The overview documents are hyperlinked to the documents referenced in the footnotes so that members of the public can see the evidence that underlies those exhibits. In addition to distilling the evidence contained in the 135,000 documents into the overview documents, Commission Council have also interviewed over 100 people who we believed had information that they could share with the inquiry. The people came from many walks of life, current and former city employees, consultants retained by the city, staff of the Ministry of Transportation of Ontario, and many others. We interviewed many more people than we will be calling as witnesses at the inquiry. The combination of the overview documents and the interview process allowed us to determine where it was not necessary to have persons attend to give live evidence. And we'd like to thank all of the people who prepared diligently and gave us their time during the interview process, as well as their counsel for preparing them so well to assist us. So we have now arrived at the start of the public hearings. Generally, the inquiry will hold public hearings on Monday to Thursday, although there will be variations in this schedule. This week, for example, we are sitting Monday through Friday. A typical hearing day will look like this: a 9:30 start, a 4:30 finish, and a lunch break from 1 to 2:15 p.m. There will be a 15-minute break in the morning and the afternoon, and all council are committed to trying to keep to that schedule, even though it will prove challenging from time to time, no doubt. Again, there will be variations in the daily schedule. From time to time, we will sit a little bit later where we think we would be able to complete an examination, for example. Today, we will have a short day because of witness availability. I wish to remind viewers and members of the public that a public inquiry is not a trial. Although the witnesses will be under oath, it is still not a trial. The commissioner is not asked to and is not permitted to make findings of civil liability or criminal misconduct. This is an exercise in establishing relevant facts. Commission counsel will ask the bulk of the questions to witnesses, as it is our role to present the evidence in a fair and comprehensive manner. Counsel for the participants will be allowed to question witnesses for a period of time to be determined by the commissioner. The first witnesses to be called will provide some background information on some of the scientific issues that will inform the work of the inquiry. After that, we will be calling evidence related to the design and the construction of the Red Hill Valley Parkway. We will then hear from 11 witnesses from the Ministry of Transportation of Ontario, and we anticipate that that evidence will take us through the end of May. From there, we will move to evidence primarily from city employees and consultants retained by the city. The list of anticipated witnesses starting after May has been updated on the Red Hill Valley Parkway Inquiry website and now includes those witnesses. The anticipated dates when these witnesses are expected to give their evidence will be posted on the website on a rolling basis. But we anticipate that this block of evidence will take us through the end of August. We will then adjourn the public hearings to prepare expert and policy evidence that will be based on the evidence heard in the first phase for a second phase of the public hearings that will start in the fall of 2022. With that introduction to where we have been and where we are going, there are really two matters left for today. First, I will turn it over to my colleague, Andrew Lewis, who will describe what's going to happen for the next 2 days. And then after that, we will deal with the City of Hamilton's motion for directions. So unless you have any questions for me, Commissioner, I will turn it over to Mr. Lewis. Thank you.
Thank you, Mr. Senta. Commissioner, as you know, the first two witnesses will be Dr. Gerardo Flinch and Mr. Russell Brownlee. Both have provided expert reports. Dr. Flinch will present tomorrow and Mr. Brownlee will do so on Wednesday. Dr. Flinch's report is titled Primer on Friction, Friction Management, and Stone Matrix Asphalt Mixes. Dr. Flinch is a professor of engineering at Virginia Tech in Virginia, United States of America, and is the director of the Center for Sustainable and Resilient Infrastructure at the Virginia Tech Transportation Institute. Mr. Brownlee's report is titled Principal Design and Maintenance Standards, Guidelines, and General Practices for Ontario Highways. Mr. Brownlee is the CEO and a principal of True North Safety Group in Toronto. The purpose of their expert reports and their evidence this week is not to opine or comment on specific facts pertaining to the Red Hill Valley Parkway. Rather, the purpose is to provide a base of knowledge to assist you, the participants, and the public in understanding and interpreting concepts, technical terms, and evidence that may be presented subsequently. Dr. Flinch's report, in part, outlines the use of friction investigatory or intervention levels as part of friction management programs, primarily focusing on jurisdictions outside of Ontario and Canada. And by investigatory levels, I mean stipulated measured friction numbers or values at or below which a highway agency is required to investigate whether friction on a roadway is too low. By intervention levels, I mean stipulated friction numbers or values at or below which actual remedial action is required. And as Mr. Senta mentioned, with respect to Ontario, many individuals currently or formerly employed at the Ontario Ministry of Transportation will be called as witnesses. And in addition to testifying with respect to the Ministry of Transportation's involvement in conducting friction testing on the Red Hill Valley Parkway, a number of these witnesses will testify as to MTO practice and policy respecting highway friction management in Ontario, including, but not limited to, its use of approved aggregate sources for use in surface course asphalt pavements, the standards applied in evaluating the characteristics of those aggregates, and its maintenance of a publicly available approved aggregate source list. We anticipate that individuals from the Ministry of Transportation will also explain the MTO's approach to friction measurement and its use of the ASTM locked wheel skid tester for that purpose. In addition, the participants to the inquiry and Commission Council are supplementing Dr. Flinch's report and evidence and the evidence of the MTO witnesses with a short document titled The Agreed Summary of Pavement Friction Practices in Canada. And could the registrar please call up that document, RHB 932, Agreed Summary of Pavement Friction Practices in Canada. This document has been agreed to by the participants and Commission Council as reflecting at a high level friction management practices, and in particular, the lack of published or publicly available standards setting friction investigatory levels and intervention levels in Canada. As well, this document provides some additional but by no means comprehensive information respecting Ontario's friction management practices. The short summary of this summary document is that there are no published or publicly available national or provincial investigatory level or intervention level friction standards in Canada, and that includes Ontario. But as I said, you will hear extensive evidence about the MTO's approach to friction management and measurement from their witnesses. And there is extensive evidence around those issues in overview document 4. Already introduced as an exhibit by Mr. Senta. Commissioner, I would ask to make the agreed summary of pavement friction practices in Canada, RHV 932, an exhibit. And I believe that would be exhibit 12. Sorry, it's 11. 11. 11. And with that, I would turn it back to Mr. Senta for the last matter for the day. Thank you.
That leaves, Commissioner, only one more thing to do today. The City of Hamilton has brought a motion for directions regarding a privilege dispute. The relevant materials for use on the motion for direction have been assembled in a book of documents. Could I ask the registrar, please, to call up the bundle of documents labeled City of Hamilton, Motion for Directions, Privilege Dispute Process, April 25, 2022, Materials for Use on Motion. Thank you, Registrar. And if I could ask that this bundle of materials, which is Bates number that corresponds to the image numbers within the PDF, if we could mark that as Exhibit M1, and we will use that convention going forward to separate out if there are any other motions, that the material filed on the motions will be exhibited separately under the heading M1 and so on. If you, Registrar, please go to image 2 of Exhibit M1. The materials that we are putting before you today, Commissioner, include the City of Hamilton's Notice of Motion dated March 25th, 2022, a list of the withheld disputed documents, a list of the redacted disputed documents, a letter from Commission Counsel to Counsel for the City of Hamilton dated November 22nd, 2021 that describes the process that the City and the Commission Counsel engaged in. And finally, a letter from the Hamilton Spectator dated April 7, 2022. And I can confirm that in my discussions with Counsel for the Spectator, they were content to have their letter placed before you, Commissioner, and but did not wish to make further oral submissions on the motion for directions, that they were content to rest on their letter. I understand today that Counsel for the City and Counsel for Golder Associates will speak to this motion, following which I will make brief submissions to you. And I invite Mr. Letterman on behalf of the City of Hamilton to speak to the motion.
Thank you, Mr. Senta, and thank you, Commissioner. This is a motion for directions which the City of Hamilton is bringing to appoint a designate pursuant to Rule 15 of the rules of procedure for the public hearing to determine the claim for legal privilege with respect to 43 unique documents over which the city has maintained privilege and is the subject of a dispute as to whether or not those 43 documents are validly privileged. Second, the motion for directions is to direct that the designate, that the hearing before the designate be heard in camera, and any motion materials filed with redactions so as to protect information that may be subject to legal privilege, including solicitor-client privilege and litigation privilege. And thirdly, this motion is to seek in order to direct the designate to ensure that his or her decision be made public, subject to any redacting of any portions of the decision which are necessary to protect privileged information. And if I may, Commissioner, let me just provide a couple of points by way of background. Pursuant to Section 33 sub 13 of the Public Inquiries Act, any information that is protected by legal privilege is inadmissible at an inquiry. The City of Hamilton has produced over 62,500 documents that were potentially relevant to the terms of reference and responsive to the summons. In addition to those documents, the city identified a number of documents which are subject to legal privilege, including documents that contain legal advice or were prepared for the dominant purpose of litigation. Initially, the city withheld approximately 1,000 of such documents on the basis that those documents were subject to legal privilege and therefore inadmissible at the hearing stage of the inquiry pursuant to Section 33 sub 13 of the Public Inquiries Act. In February of 2021, Commission Council advised the city that it did not agree with the city's assertion of privilege over these documents, asserting that the city had waived privilege over all documents relevant to the inquiry. The city subsequently produced unredacted copies of these documents to Commission Council on a without prejudice basis to permit Commission Council to review and identify the specific documents which Commission Council deemed relevant to the work of the inquiry. And the city worked cooperatively with Commission Council to find a balanced approach that would allow Commission Council to have access to the information that was truly relevant to the terms of reference, while also protecting the privileged nature of the information. Following those efforts, the city agreed to produce the majority of the documents which Commission Council identified, though while maintaining the assertion of privilege over 43 unique documents. It's a total of 87 when you count duplicates and partial email chains, but in essence, it's 43 unique documents. Those are the documents that are the subject of a dispute. Commission Council has indicated that it wishes to challenge the city's privilege assertion over those documents. And we have conferred with Mr. Senta and his team, and they support this motion for directions to appoint a delegate to adjudicate this question of privilege over these documents and to have the hearing of that process held in camera. I do want to address, if I could, Commissioner, just the basis for seeking the orders that we do here today. pursuant to Rule 15C of the rules, provides that the commissioner may appoint a designate to exercise the powers of the commissioner in respect of the determination of claims of privilege. And indeed, that practice of appointing a designate to adjudicate privilege claims has been followed by a number of other public inquiries. For example, in the Elliott Lake inquiry, Justice Gouge, who was a designate of the commissioner, the Honorable Paul Bélanger, adjudicated the privilege claims asserted by two summons parties over a number of documents that were relevant to the inquiry. Similarly, in the Gouge inquiry, the Associate Chief Justice of Ontario was appointed as a designate of the commissioner to adjudicate privilege claims asserted by the Kingston Police Service. In my respectful submission, Commissioner, appointing a designate to review privilege claims is consistent with also Justice Bellamy's recommendation in her report following the TCI inquiry that issues of solicitor-client privilege be resolved by reference to, in that case, the regional senior justice of the Superior Court of Justice or a judge designated by him. Let me also, if I could, Commissioner, highlight Rule 37 of the rules, which empower the commissioner to direct that matters within the inquiry proceed in the absence of the public where such a direction is in the public interest. The city seeks direction to have the privilege motion adjudicated in camera, as that would ensure that the privileged information contained in the 43 documents at issue would remain confidential in the event that the delegate determines that the documents indeed are privileged. If the motion is not held in camera, or if the motion materials are made publicly available without redactions, the parties would be prevented from referencing the privileged information in their submissions, which would make the adjudication process much more challenging for the designate to adjudicate the question of privilege if the parties and counsel cannot make a specific reference to the privileged information. We understand that Commission Counsel has agreed that the motion ought to be heard in camera and that the materials ought to be made publicly available but redacted to protect the privileged information contained within these documents. We've also seen the correspondence from the Hamilton Spectator, which has opposed a total in-camera hearing for the motion and proposes that only those portions of the motion where the impugned documents are actually being discussed are to be held in camera. While the city is certainly not opposed to that concept in principle, practically speaking, we anticipate that much of the parties' submissions on the privilege motion will necessarily need to focus on the content of that privileged information, which could not be done or conducted in open court or in a public forum. Certainly, the city would be pleased to work with Commission Counsel on the lead up to the motion to assess whether there are any portions of the privilege motion that could be heard publicly. But practically speaking, there will be some challenges with doing that, given the entire nature of the motion involves the adjudication of the question of legal privilege. I know that Ms. Roberts is going to speak on behalf of Golder, but I do want to make reference to the fact that the city is aware that Golder wishes to make written submissions on the privilege motion with respect to the city's claim for privilege. And I would like Commissioner, for you to know that the city is not opposed to Golder making such written submissions, but it should not, in our respectful view, receive access to the privileged documents in question, which are the subject of the adjudication process, which we propose to be heard by the designate. Subject to any questions, Commissioner, those are my submissions with respect to the motion for directions.
No questions at this point. Thank you.
Thank you.
Ms. Roberts, would you wish to make submissions at this time?
I think,
Mute. Thank you, Commissioner. Thank you. First of all, we take no position in relation to the relief sought in the motion for directions. And in response to the point made by Mr. Letterman that Hamilton doesn't oppose our making written submissions, but would oppose us seeking access to the documents, I confirm that we are not seeking access to the documents themselves, but only seek the opportunity to make submissions in relation to the privilege, and essentially for the purpose of expressing the view as to why it is relevant to Golder.
okay.
And as you know, Golder's position is, and the evidence that we anticipate that will come out, is that it delivered the Tradewin advice to the city of Hamilton, enclosed within the Golder report, and provided an assessment of friction as well as recommendations in early 2014, and then subsequently provided its assessment and recommendations on a number of subsequent moments in March of 2016, and then at least in 3 occasions in 2018. We anticipate, Mr. Commissioner, that as part of this process that you will seek to scrutinize the extent to which Golder was effective in communicating its findings and recommendations. And it is our position that in order to do so fairly, that it will be important to see the full spectrum of the evidence as to what happened with the report, what happened with the advice internally within the city of Hamilton, and particularly within its legal department. And for that reason, we seek the opportunity to have our voice heard at that motion. Thank you.
Thank you.
Those are my submissions, subject to your questions.
I have no questions apart from asking Mr. Santa, do I then take it that there is no objection to the request of Golder's as stated today, simply to make written submissions?
No, Commissioner. Commission Council supports both the city's motion for direction and Golder's request to be able to make written submissions to the delegate. In our view, it is appropriate to appoint a delegate to determine this matter. In our view, it would be open to you to review the documents. However, we agree with the city that in these circumstances, it is appropriate to appoint a delegate to review this collection of documents. Commission Council is very mindful of the concerns expressed by the Hamilton Spectator, and we agree that the dispute resolution process should be as open as possible, but the process in our submission cannot destroy the very privilege that the city of Hamilton is asserting. It would be would not be an appropriate outcome for the process to determine whether or not they have a valid claim of privilege or to destroy the subject matter of the privilege. So we encourage you in your direction as set out in the request for relief from the city to allow a process that is open as possible, but that adequately protects the privilege asserted by the city of Hamilton. And as Mr. Letterman said, we are happy to work with the city to ensure that the materials are redacted as fully as required, but are as open and transparent as possible, to try and achieve both the goal of openness and transparency that lies at the heart of a public inquiry, while at the same time ensuring that any subsisting legal privilege is not violated. Those are my submissions, unless you have any questions. Oh, finally, I just agree that it is appropriate to allow Golder to make written submissions, particularly given their statement that they're not interested in looking at the documents that are subject to the privilege claim. In those circumstances, it's entirely appropriate. We agree with the city that written submissions from Golder could be quite helpful to the delegate. In terms of the oral submissions to the delegate and whether they need to happen in camera, I think I agree with Mr. Letterman that we will see what the delegate would find helpful, but the goal of the oral submissions will be to assist the delegate to reach the determination. And I suspect that what will be of most assistance to the delegate is a careful document by document, fact by fact discussion of the privilege, the existence of the privilege, and whether it is continued to this date. And that is not a set of submissions that can readily be made in public, but we will work together with the city and the delegate to see what would be helpful in determining this matter.
Thank you.
And those are my submissions, unless you have any questions for me.
I don't accept to say I understand there may be some agreement with respect to the arbitrator for the delegate.
If you make the decision to appoint the delegate, we believe that we will be able to appoint a delegate to fulfill that task very quickly.
Okay. I have no further questions. This is a matter that I will provide directions on after the close of this session, before the opening of tomorrow's session.
Thank you. Unless any of the council for the participants have anything to add, that would bring to conclusion both the motion for directions and the matters that we wished to put before you today, Commissioner. Unless anyone has anything to add right now, we will return at 9:30 tomorrow for the first day of live evidence.
Okay. Thank you. We'll stand adjourned until 9:30 tomorrow morning.
Thank you.
Thank you.